Having done Social Security disability law for over 30 years, I'm very familiar with the rules and the regulations that define a disability under the Social Security Act. When I have a claimant call, typically it's because their doctor has told them they're disabled, they can't go back to work. And when you file for Social Security disability, there's a little bit more to proving that you meet the disability criteria. So when a person comes to me to represent them on their Social Security disability claim, what I can do is help educate them on the types of actual evidence we need to get from their medical sources to document that they meet the disability criteria. It's not just their doctor saying they're disabled, it's their doctor saying why they're disabled. Putting that information together in a form that when we go to a hearing, we can present it in a manner that convinces the administrative law judges who hear these cases that they do meet the disability criteria. It's not a matter of judging somebody. It's not my job to be the judge. I'm the lawyer. My job is to find out what their disability is and try and put the evidence together to prove it as best we possibly can under the law and present it to a judge. That's who's going to decide if they're disabled or not. That's not my job. My job is to help them put their case together as best that they can to present it in front of the administrative law judge. The judges who hear these cases are administrative law judges that come down from an office in St. Louis, and there are about 12 judges for each ODAR, as we call them, Office of Disability Adjudication and Review. And having done Social Security disability law as long as I have, I've probably had hearings with every judge that is at the hearing office. And I think it makes a difference when you do a disability hearing and you know your judge. These judges are very professional, very personal people, but they're human, and they all have preferences on how they like a case presented, what kind of evidence they find persuasive. Knowing ahead of time what your judge likes or what your judge wants to hear about, and presenting that evidence before the hearing and also with your claimant at the time of the hearing, I think is a big advantage to have everything you know that judge wants to have right there on the day of the hearing available and ready to go as evidence. Most of the claimants that I represent in my Social Security disability practice typically have already been out of work for a period of time, probably 6 months or more, with no income from their source of employment. Most of these people are in enough of a quandary about what their true medical problem is, much less how do they pursue legally their claim for disability insurance benefits. Sometimes in the media, people who file for disability benefits are portrayed as people who just don't want to work. Well, that just really is not the case. These people are hardworking people. These are people who have been supporting their family many times for 20 years or more because of a injury or an accident, maybe a car accident. They can't go back to work, so they've lost that source of income, and they are the people that the Social Security Act was there to provide for. So in my disability practice, when people come in, it's just a matter of trying to help them navigate the disability process as quickly and as efficiently as possible so that if they are found eligible for disability benefits, they can get an income back into the family so they don't lose their homes, so they don't lose their cars, so that their kids can still go to college. I like what I do. I like dealing with the people that I represent in Social Security disability law. When I get up in the morning and come to work, I feel that what I do is valuable for people. It helps people out. It's a kind of a practice where you go home feeling like you've made a difference at the end of the day, and that's the kind of law I always wanted to practice.